morning, and welcome to the September session of the Court of Criminal Appeals. And happy National Punctuation Day. I know punctuation has to be near and dear to the hearts of those present today. Let me introduce our panel. To my right is Judge Robert Montgomery from Kingsport, Tennessee. To my left is Judge Jill Ayers from Nashville, Tennessee. And I'm Camille McMullen from Memphis, Tennessee. I see familiar faces here. You all know the drill. 20 minutes per side. If the appellant wishes to reserve rebuttal time, we are operating on the light system, but please let us know so we can kind of help you keep track of that information. Madam Clerk, any preliminary matters? Call the first case.
State of Tennessee versus Joshua Anthony Williams.
May it please the court, my name is Jonathan Harwell. I'm here on behalf of Joshua Williams. With me at council table is Hallie Hammond. If I could reserve 3 minutes of my time for rebuttal. Briefly, I want to just remind the court of the facts and then move on to the arguments that have been raised. Mr. Williams was indicted for rape. Allegation involved his 13-year-old cousin at a time he was 18 years old. He pled to statutory rape, and defense counsel was very clear throughout and including at the plea hearing that there was no stipulation or agreement as to any acts of force. They disputed the acts of force, but accepted that the elements of statutory rape had been proven. There was agreement as to a 4-year sentence. There was a sentencing hearing held, and at that hearing, the state did not present witnesses as to the incident.
Was the sentence a 6-year or 4-year split? I read, as you know, we are mildly familiar with the records. We've read your briefs fully and carefully. But in terms of the sentence, was there a split sentence here that was agreed upon and it was just the manner of service?
It was a 4-year sentence that was
Okay.
agreed upon. It actually, I think to the surprise of the parties at the sentencing hearing, the court made the diversionary period 6 years.
Okay, that's where I was.
But it's still actually a 4-year sentence.
Okay.
As I said, sentencing hearing, defendant was placed on the registry, but diversion was granted. There are two main arguments that I would like to address. There's a third issue I certainly want to get to is our entitlement to be here at all on a right as to our appellate rights, and I would propose discussing that one third. As to the first issue, this has to do with the situation of whether an individual who is granted diversion can also be placed on the sex offender registry. It has to do with the interaction of the sex offender registry statute, which defines, say it's imposed upon judgment of conviction, but also talks about conviction includes a sentence imposed under the diversion, or a plea taken under the diversion statute. The other relevant statute, though, is the diversion statute, which says that when a diversion is taken, further proceedings are deferred, and there is no entry of a judgment of guilty.
Mr. Harwell, can you answer this question for me? Is there a difference between arguing to the trial court that an individual is not, or it isn't appropriate to place an individual on the sex offender registry versus that the trial court has no authority to place an individual on the sex offender registry?
Yes, I think there absolutely is.
Did you argue before the trial court that because the defendant was placed on judicial diversion, the court did not have authority to impose the sex offender registry requirements?
That argument was not made at the
Okay,
hearing.
So help me understand why this issue is not waived.
I think it's not waived in the sense, well, two senses. One, what is being appealed is the placement on the sex offender registry. Even if the argument wasn't made at the hearing itself, if that placement is legally invalid because a judge does not have the authority to do that, then I believe that claim can be raised at any time. There was no agreement that you can, that placement on the registry is appropriate.
Well,
Counsel-
the trial court conditioned judicial diversion on compliance with the sex offender registry, correct?
It first imposed registration and then ordered diversion. In its discussion of diversion, obviously one of the conditions of diversion is going to be compliance with probation, which includes registration.
And had you argued that the trial court did not have legal authority to impose the sex offender registry requirements as a condition of judicial diversion, do you think the trial court would have made a different determination?
I don't know. I think that's the answer.
So how are we to know, if you didn't argue it below, how are we to, you've been here many, many a time. How are we to say that the trial court erred in doing so?
I disagree in the sense that counsel certainly argued to the trial court that registration was not appropriate.
Sure.
Did not argue it in precisely the same way that I have argued it on appeal.
Are you saying that this is a nuance? Because that's why I asked you at the top, is there a difference between the two questions?
I think there is, they're obviously different questions. I think they're closely enough related. In particular, if the issue that is being raised here is it was not legally authorized. I think that's I don't want to use the word jurisdictional, but it's essentially it's a fundamental legality issue. And I would point the court to Your Honor's opinion in the Townsend case, obviously for the substantive analysis in Townsend.
Where they directly argued the authority of the trial court, and the trial court was grappling with its authority of whether it was required to impose the sex offender registry requirements. This court didn't have that opportunity because you did not argue it.
That was not argued below. I'm trying to remember to the extent which it was argued below in the Townsend case. But I do think when we're talking about an issue of whether the court had the authority under the governing statutes, we're talking about if it's a trial issue, I think maybe there could be an issue of waiver. We're talking about a sentencing issue. Anytime we have a sentencing issue and the argument on appeal is the trial court did not have the authority to make that decision, I believe that's not an issue that is waived. If this is an illegal judgment in the sense that there's a contradiction between diversion and registration, this court is entitled to consider that. And the state has not cross-claimed or otherwise raised an argument as to the propriety of the diversion decision. So I think that's relevant as well. Just to go back to the Townsend decision and this, I think what is in essence a common sense understanding that there is a contradiction here.
I agree. I know that comes to no surprise to anyone.
I was telling opposing counsel that I did have to change my argument a little bit, and then my argument was going to be, don't listen to me, just read what Judge McMullen has written.
I don't know, Judge McMullen might have a little disagreement there.
The one thing, though, I think that is actually different from this case is post-Townsend. So to the extent that maybe the state obviously disagrees with the Townsend's decision's logic, I think that we're in a different position even now, in the sense that if there was confusion beforehand, before Townsend, as to how to resolve these contradictory statutes, certainly there's more confusion after Townsend. That is, that in order to conclude that registration can be imposed on a diverted defendant and not to need to refer to rules of lenity or due process concerns.
So even if we get to your argument, I found compelling the state's footnote regarding the floor debates post-Townsend to the amendment to the sexual offender registry to include a more refined definition of conviction. The legislature spoke after Townsend. Can you address that?
The legislature did speak, but it didn't actually, it spoke only in passing a different statute. So to the extent that Townsend was talking about, there's a contradiction between the diversion statute and the registry statute, the primary registry statute defining what a conviction is. What the legislature does on some other statutes, even what they say on the floor as to what they're intending to do on those other statutes, I don't think that has any actual relevance to the interpretation of these two statutes, which were not changed by the legislature. The legislature in, I don't remember the year, in 2018, could have gone back and changed one of these two statutes to clarify how they should be interpreted together. But it didn't do that. It passed a new statute that dealt with a different situation. It certainly indicated that that's how it interpreted those statutes.
Was there not specific language where they spoke to convictions, specifically statutory rape, and said that if an individual pleads guilty to the offense of statutory rape, this is to require them to go on the sex offender registry, or those conditions can be imposed during the period in which they are on judicial diversion?
I think that's right. I think the legislature's current interpretation is probably consistent with what the state is saying.
Okay.
But their current interpretation, if they're not amending or passing or dealing with the two statutes that are at issue, what they think about them is irrelevant when they're passing a different statute.
Okay.
I do want to move on to the other argument, which has to go with the ruling of the court. I think there is, as the state's pointed out, a tension in my arguments in that I'm not sure how to interpret what the court was doing. One possible interpretation is that although the defendant and defense had never stipulated or agreed to any acts of force, that the trial court was taking into account, even if only a very small way, the initial idea that this was a forcible rape. So the trial court said, I don't think you have to go too far beyond the stipulated facts. And it's my position that you actually can't go beyond the stipulated facts at all. So that's the first idea, is there was never any proof of force. At the plea hearing, there was discussion of maybe they'll try to prove it at the sentencing hearing. The victim did not appear and testify at the sentencing hearing. There was no substantive evidence introduced of force. So possibly what the trial court did, which was erroneous, was rely on this unproven allegation of force. Or, as the state says, well, actually, it didn't rely on anything, went just on the basic stipulated facts. And there is part of the trial judge's ruling is basically saying, you have an 18-year-old, you have a 13-year-old. I believe because of those ages alone, that regardless of force, that's the act of a predator and registration is required. It's our argument.
If you take everything that the trial court said, I mean, you're taking that last sentence before, where he focused on age, and then he said he was a predator, and then he imposed the sentence. But everything that he said focused on the relationship between the defendant and the victim here, not just age, and the fact that he was living in their house. I mean, I looked at what the trial court said, and it seems like you're really isolating one or two sentences to make your argument. Is that a fair assessment? I mean,
I think that the trial court actually said very little justifying the registration decision. It mentioned 13, 18, mentioned their cousin, and something about you'd see your cousin at a birthday party so you know how old they are. There was a further discussion of the facts, but that was in the after he had ruled on registration, and that's in the context of the diversion decision. I think it is entirely fair to characterize the court's ruling as to registration to be a categorical one. Anytime there is an 18-year-old and a 13-year-old, I believe that is predatory, and I would put anyone in that situation on the registry.
he didn't say that.
Yeah,
mean,
I was going to say, I have to
Go ahead,
agree with
Harris.
what Judge McMullen is saying. It seems like you're taking that out of context of what the trial judge did say with regard to the whole relationship, not just the ages. I know he did focus on the ages, but there was more than just that.
The record will speak for itself. I don't think I'm exaggerating. I mean, I think the portion leading up to the registration decision is very limited.
Can you help me with your legal argument? Are you saying just that he didn't make sufficient findings to support imposition of the sex offender registry? Or are you saying that trial courts should have a separate findings of fact or a separate rubric to make a sex offender registry? Help me with your argument, because you know this is advisory. The totality of the sentence is advisory, period. So help me with what you're saying.
I think I'm taking essentially guidance from the kind of alternative sentencing holdings of the Supreme Court, saying that alternative sentence, or in this case, a registration, can't be just based on the elements of the offense itself. If the legislature has made alternative sentence, or here registration, discretionary, then there has to be some analysis of the specifics of the situation. It can't just be, in essence, I disagree with the legislature that registration alternative sentence should be available in this situation. So alternative sentence, often you talk about, you have to find the circumstances were especially egregious or horrific compared to the average case. Here, you just have this judge, I think, saying legislature has said that registration is discretionary for 18-year-old with a 13-year-old victim, and I disagree with that. I think that's a fair interpretation of what the judge said. I have 3 seconds to cover the right to appeal. I will take a little bit of my rebuttal time. 2 quick points. One, I think to the extent that we are doing something, or that the word conviction is being used in different contexts in different ways, I think it is very unfair to say a conviction is good enough to get someone on the registry, or diversion is enough of a conviction to get them on the registry, but not enough of a conviction to allow them to appeal. The second more important point, I think, is if we're proceeding under Rule 10 or common law writ of certiorari, the essence of those doctrines is this court doesn't sort of second-guess meddle with intermediate decisions of a lower court. And that's not really what is at stake here. This is a life-changing decision. For at least 6 years, this man is going to be under an extremely harsh regime that make it difficult to get a job, make it difficult to live, difficult to have relationships. That is an enormous imposition of his rights.
Great question, I'm sorry. When you're on the sex offender registry, can you apply to the court to have it condition removed?
Not until a certain period of time passes.
Okay, and if you're on diversion, and does the statute make reference to that? You say that there's a time period. What's the time period?
So some offenses, I think it's 10 years, some offenses it's never. There is a separate statute, going back to the earlier discussion, that seems to say if you're on diversion, at the very least, when you finish the diversion, you will come off a registry if you were on the registry.
Okay, so if it's a condition of probation, does the judge, because it's not a conviction, would the judge have the authority to remove him from the sex offender registry?
I assume the state would disagree. I mean, it's my position that the judge doesn't have the authority to put him on in the first place.
In theory, do you think the judge would have that right?
Only in the sense that I don't think that it's our argument the judge doesn't have the authority to put him on. But just to make my final point, this court and the appellate courts are not without power. The factors for Rule 10 of the common law writ talk about someone losing some important right that will otherwise never regain. Mr. Williams is going to be under an oppressive regime for the next 6 years of his life that is going to change the course of his life. He has a right, whether it's under Rule 3 or Rule 10, I believe this court, I think our system owes it to him that someone should review whether that was a correct decision. Thank you.
Thank you, Mr. Harwell. General Orr?
Mr. Harwell is quite a bit taller than me. May it please the court, Courtney Orr on behalf of the state of Tennessee. I'll start first where the defendant ended, which is this appeal should be dismissed. It comes to this court as on a Rule 3 notice of appeal, and the Holcomb decision, binding authority from this court, shows or explicitly states there is no Rule 3 right of appeal from the grant of judicial diversion. There is a slight difference here from Holcomb, where Holcomb was not challenging the authority to place the defendant on the sex offender registry. Instead, it was simply a discussion of the discretionary placement for statutory rape. Here, the defendant is challenging that authority, but it is our position that this does not raise this claim to a Rule 10 extraordinary appeal. Simply put, the defendant cannot get around the strictures of Rule 3 by raising a meritless claim that the court did not have authority to place him on the sex offender registry. When you look a little bit behind the defendant's claim, and I believe Rule 10 requires you to look at the merits of the claim and not just the claim itself that's raised in the brief. When you look to the merits of the claim, it is clear that the trial court had the authority to place a defendant who was granted judicial diversion on the sex offender registry for the duration of that diversion. The court was not operating outside of its stated authority, and a Rule 10 appeal is not appropriate here. So we would submit that this appeal should be dismissed. Turning to the court's authority to place Williams on the registry, and Judge McMillan, I understand you disagree with our interpretation of Townsend here, but I believe Townsend did not engage with one rule of statutory interpretation, but subsequent amendments have made it clear that the legislative intent was for the trial court to be able to place defendants who plead guilty to statutory rape and are granted judicial diversion on the sex offender registry for the duration of that diversion. First, there is simply no contradiction between the judicial diversion statute and the sex offender registry statute. The sex offender registry statute very clearly says that a plea entered in pursuant to Section 313 is deemed a conviction solely for the purpose of placement on the sex offender registry. When you look at the judicial diversion statute, it says, it prescribes the procedure for how this plea should be taken, how the conviction should be held in abeyance, and completion of the diversionary term. And the judicial diversion statute says that the benefits of diversion, not treating this plea as a conviction, are only accrued to the defendant after successful completion of the diversion. It states that once the defendant has successfully completed diversion, once the conviction has been wiped from the record, then it may not be deemed a conviction for any other purpose. To me, that says that the definition within the judicial diversion statute of what is this plea within the term of diversion can be considered a conviction for the purposes of the sex offender registry. And the sex offender registry explicitly defines a judicial diversion plea as a conviction for the purposes of the registry. That statutory definition controls, even if the ordinary meaning of the term, Judge McMullen, would create some confusion and ambiguity. So it is our position that the statutory definition is the controlling analysis here, as opposed to Townsend, with my respect, Your Honor. But further, amendments since Townsend have shown that the ambiguity that was left after Townsend, and there was some ambiguity when Townsend was decided on what happens to defendants after they complete diversion who have been on the sex offender registry. At the time Townsend was decided, the registry was silent on what happens to those defendants. And that was the issue in Dill, which Townsend relied on, is that Dill was in fact violated for registry terms after he completed diversion. But after Townsend, the legislature returned to the sex offender registry to figure out how can we resolve this confusion and ambiguity. And even though opposing counsel believes they should have amended the statute specifically at issue, to be quite honest with this court, I do not know how you could make the definition of conviction within the sex offender registry more clear. Instead, they looked to the other area of ambiguity, which was what happens to defendants after they complete judicial diversion. And they made it explicitly clear that for defendants who complete judicial diversion and are on the sex offender registry, once their diversion is completed, they may petition to be removed from the registry, and they will be relieved of their registry obligations at that point. That resolves any ambiguity that was left after Townsend. And as Judge McMullen, you pointed out, in the floor debates in both chambers discussing this amendment, they specifically cited statutory rape as a conviction for which this procedure would apply. Simply put, there is no contradiction between the judicial diversion statute and the sex offender registry statute, and the trial court was operating well within its authority when it placed Mr. Williams on the registry. Judge Montgomery, I did want to briefly address some of your questions about the court's authority to remove. Opposing counsel is right that if it's a sexual offense, petitioners or offenders can petition to be removed 10 years after they are released from confinement. Violent sexual offenses, they can never be released, assuming they're convicted. This is not a judicial diversion. For most offenses that are an automatic registration requirement, the court does not have authority to remove specific terms of the registration requirement. I do not believe this court has looked at whether discretionary placement on the registry can result in discretionary terms of the registry. The state's position is no. A conviction is a conviction. Once you are placed on the registry, you are required to comply with the terms of the registry for the duration that you're on the registry, be that 10 years after your confinement, for your life, or in the case of judicial diversion, until you complete diversion. The only offenders that would be exempted from some registry requirements are violent juvenile sexual offenders, which have much reduced obligations under the registry, and offenders against minors are permitted to live with their own children if they still have custody of their children. I just wanted to answer some of your questions there. Finally, unless there are any other questions about the authority, here the court properly exercised its discretion when it placed Mr. Williams on the registry. Clearly, opposing counsel and I have different interpretations of the record here, but when you read the record in context, and I understand this court may have reviewed some of the findings but have not read the whole record, this sentencing hearing, for lack of a better word, was very clear. The court started with its consideration of the registry placement, made those findings, and then it turned to judicial diversion. The parties are not challenging placement on diversion. Instead, we are looking only at placement on the registry. And the court's findings for placement on the registry were, I'm not considering any of the preliminary hearing testimony that was introduced without objection from the defendant. It found that, or it could consider, it was said, I'm considering this as a statutory rape, but I can consider whether this is worse than other statutory rapes. And to find that it was worse than other statutory rapes, the court found the victim was 13, just a few months older than what the threshold for rape of a child. The defendant was 18. The defendant was more physically, emotionally, mentally mature than the victim. And this was qualitatively different than a 22-year-old raping a 17-year-old. That the maturity that occurs within those 5 years from 15 to 18 was a factor to be considered here. Now, did the court specifically say this, saying, I find Mr. Williams this, I find the victim is 13? No, he was speaking in more generalities, but read in context, it is clear this is not a categorical statement about all 13-year-olds and all 18-year-olds. This was this victim and this defendant had enough of a difference that this court found that the facts of this statutory rape justified placement on the sex offender registry. But it didn't stop there. It also found that the defendant lived with the victim and her family, that he knew how old she was, that he had been to birthday parties with them, and that he had acted in a predatory manner in order to effectuate this crime. Simply put, all of these factors were well within the proof presented, both at the stipulated hearing and within the psychosexual report that was entered at the sentencing hearing. And they all support the trial court's finding that placement on the registry was necessary for the duration of the defendant's diversion. Unless there are any questions from this court, we ask that you first dismiss the appeal or, an alternative, affirm the judgment of the trial court. Thank you.
Your rebuttal time.
With the court's indulgence, I'll make two brief points
Sure.
because I have used
We've
my
kind
time.
of pummeled you a little bit, so we'll allow you some liberties.
The first is to look at the language of the diversion statute itself. And I've mostly focused on the fact that statute says that it doesn't end in entering a judgment of guilty. But the first sentence of that statute actually begins, the court may defer further proceedings against a qualified defendant. I think that's important also, because the idea of the diversion is we're stopping this train. We're stopping here. You're going to be on probation for a while. You're not getting a judgment of guilty. I think there's a tension between that and what happens here, or what happens in this kind of situation, is the train didn't stop. Further proceedings were not deferred. Further proceedings were had, and that further proceeding was the decision to have Mr. Williams be on the sex offender registry. So I think it's not just the language that you're not entering a judgment of guilty. I think it's also the language that further proceedings are deferred that sets up this contrast between the language of that statute and the language of the sex offender registry statute. It's, again, our position that the court was right in Townsend that both of those can't be true, or at the very least, there is a confusion about them. I think we adequately made the point in our reply brief that this is a situation where absolutely the rule of lenity, where doctrines of fair notice apply. When you're putting someone on a completely onerous regulation, and one that any failure to comply with results in a criminal offense, those statutory tools that apply to penal statutes should apply here as well.
Well, so what's the difference between further proceedings and then the reasonable conditions that a judge may impose under 4035-313?
I think sex offender registry is not just a reasonable condition. It is in part conditions, but it is also setting someone up that if they violate, they have not just violated conditions of release that could result in revocation of a sentence. They have actually committed a new crime, and so that's a difference between a registry and just even very harsh conditions for probation. The second point I want to make is just, again, to point to the court to the relevant part of the transcript at the sentencing hearing covers a little bit over a page. I think the state accurately said the judge speaks just in generalities, and that is our complaint, that the generalities, he narrows it down in the sense that he is talking about an 18-year-old and a 13-year-old. But beyond that, he is only talking about that in general. He says 18-year-old is much bigger and more physically mature than a 13-year-old. He's not saying this man is bigger than that girl. He couldn't say that. She's not there. There's no evidence of that. He is just saying this age difference, unlike a 20 and 15, which he thinks would be different, 18 and 13 is such that it is, in his mind, whether it is pseudo-forcible or pseudo-consensual, it is the act of a predator. The legislature, though, has said an 18-year-old and a 13-year-old can qualify, shouldn't necessarily be considered the act of a predator requiring registration. So again, the idea is here, this is not a judge, it's not just him poorly explaining himself. I think he does explain himself, but his explanation is, in essence, a disagreement with the legislature as to whether 18 and 13-year-old behavior should automatically result in placement on the registry.
Thank you, Mr. Harwell.
Thank you.
Well argued, well briefed. We'll take the matter under advisement. Call the next case.